$364,895,816, a $364 million devastating verdict against Donald Trump has just been handed down by New York Justice Arthur Engoron in the New York Attorney General civil fraud case. We were waiting for that verdict to drop on Friday, and here it is, folks, and it is as devastating as it gets. It has the monetary disgorgement component in that amount of $364 million against Donald Trump and his co-defendants. It has injunctive relief, whereby an independent monitor, Judge Barbara Jones, is given additional powers. It has certain bans against Donald Trump and his adult children from engaging in business and transactions in the state of New York. It prohibits Donald Trump from taking out loans from banks that have charters in the state of New York. Let's break down this ruling, folks, and let's go right into the conclusions and order reached by Justice Arthur Engoron. Here's what it states. It is ordered that defendants Donald Trump Jr., Eric Trump, Alan Weisselberg, Jeff McConney, the Donald J. Trump Revocable Trust, the Trump Organization, and the various other Trump-related entities are liable under the 2nd, 3rd, 4th, 5th, and 7th causes of action. It is further ordered that defendants Weisselberg and Jeff McConney are liable under the 6th cause of action. It is ordered that defendants Donald Trump and Donald J. Trump Revocable Trust, the Trump Organization, and certain other businesses listed for this cause of action and claim are liable in the amount of $168 million with prejudgment interest from March 4th, 2019. It is then ordered that defendants Donald Trump, the Donald J. Trump Revocable Trust, the Trump Organization, and the Trump Organization LLC are jointly and severally liable to plaintiffs, the New York Attorney General, in the amount of $126 million on another cause of action with prejudgment interest from May 11, 2022 to the present. It is ordered that defendants Donald Trump, the Donald J. Trump Revocable Trust, the Trump Organization, and the Trump Organization LLC are jointly and severally liable to plaintiff, the New York Attorney General, in the amount of $60 million with prejudgment interest from June 26, 2023. It is ordered that defendant Eric Trump is liable for $4 million. It is further ordered that Donald Trump Jr. is liable for $4 million. It is ordered that Alan Weisselberg is liable to plaintiff in the amount of $1 million with prejudgment interest. It is ordered that defendant Alan Weisselberg and Jeffrey McConney are hereby permanently enjoined from serving in the financial control function of any New York corporation or similar business entity registered and or licensed in New York State. It is further ordered that defendants Donald Trump, Alan Weisselberg, and Jeffrey McConney are hereby enjoined from serving as an officer or director of any New York corporation or other legal entity in New York for a period of 3 years. It is ordered that defendants Donald Trump, Donald J. Trump Revocable Trust, the Trump Organization, the Trump Organization LLC, and these various other business entities are hereby enjoined from applying for loans from any financial institution chartered by or registered with the New York Department of Financial Services for a period of 3 years. And that one right there is brutal, because how will Donald Trump be able to take out any loans at all if he wants to post a bond to try to appeal this order? It then goes on to say, it is ordered that defendants Eric Trump and Donald Trump Jr. are hereby enjoined from serving as an officer or director of any New York corporation or other legal entity in New York for a period of 2 years. It is further ordered that this court September 26, 2023 decision and order is hereby modified solely to the extent of vacating the directive to cancel defendants' business certificates without prejudice to renewal upon the recommendation of the independent monitor or based on substantial evidence. It is further ordered that the Honorable Barbara Jones shall continue in her role as independent monitor for no less than 3 years. And it is further ordered that within 30 days of the date of this decision and order, the Honorable Barbara Jones shall submit to the court a proposed order outlining the specific authority that she needs and the obligations of defendants in order to effectuate a productive and enhanced monitorship going forward. As I was describing in previous takes that I was doing, I was expecting an order like that to empower retired federal judge Barbara Jones to do more than just serve as a monitor, and if she finds fraud or misconduct, to immediately flag it for Justice Arthur Engoron's attention so that there could be quick action taken, and that's what we see in this order as well. It is also ordered that an independent director of compliance shall be installed at the Trump Organization at defendants' expense to ensure compliance with financial reporting obligations and establish internal written accounting and financial reporting protocols. And it is further ordered that within 30 days of the date of this decision and order, the Honorable Barbara Jones shall submit to this court a list of persons who she recommends be appointed the Trump Organization's independent director of compliance. And it is further ordered that the clerk hereby enter judgment accordingly. And so as you just break down the buckets of the monetary damages, those disgorgement damages, you had that $168 million bucket from the first causes of action, then $126 million from that second order. You had that $60 million third bucket, $4 million for Eric Trump, $4 million from Donald Trump Jr., $1 million for Alan Weisselberg. You add these together and you get that $364 million number right here. And as I said, just in addition to that headline grabbing number, this requirement that an internal compliance person be installed within the Trump Organization at the recommendation of retired federal judge Barbara Jones, who's been serving as the independent monitor, may I add, somebody who Donald Trump and his lawyers attacked and tried to tarnish her reputation. She now has more robust authority under this order so that she can not just monitor and prepare reports, but also provide directives and quick action to be taken to Justice Arthur Engoron. So from both the monetary perspective and the injunctive relief, the limitations on Trump and his adult kids from doing business and taking out loans, this could not be more devastating at all. Let's just go through. It's a 92-page order. Why don't I just go through with you some of the highlights of this decision so you can see the structure of this decision, how it is written. I'll give you kind of a high-level summary of it right here. Donald Trump and entities he controls own many valuable properties, including office buildings, hotels, and golf courses. Acquiring and developing such properties required huge amounts of cash. Accordingly, the entities borrowed from banks and other lenders. The lenders required personal guarantees from Donald Trump, which were based on statements of financial condition compiled by accountants that Donald Trump engaged. The accountants created these compilations based on the data submitted by the Trump entities. In order to borrow more and at lower rates, the defendants submitted blatantly false financial data to the accountants, resulting in fraudulent financial statements. When confronted at trial with the statements, defendants, fact and expert witnesses simply denied reality, and defendants failed to accept responsibility or to impose internal controls to prevent future recurrences. As detailed herein, the court now finds defendants liable, continues the appointment of an independent monitor, and orders the installation of an independent director of compliance, and limits defendants' rights to conduct business in New York for a few years. The order by Justice Engoron goes on to talk about the history of the case, the laws that are invoked here, common law fraud, the executive law section 6312 that is invoked by the New York Attorney General's office here. The order goes on to talk about the procedural background, the complaint, the summary judgment order by Justice Arthur Engoron. It talks about all of the witnesses who testified at the time of trial, going painstakingly through each of the witnesses' testimony one by one. It goes on to talk about, as it goes through the witness testimony, individual defendants, whether it was McConney, whether it was Weisselberg, whether it was Donald Trump Jr., whether it was Eric Trump. It goes on to talk about Donald Trump. It talks about how Donald Trump insisted that the values within the statements of financial conditions were not only not fraudulently inflated, as this court has already found, but if anything, they were deflated, as the following exchange with the Office of Attorney General demonstrates. Justice Engoron goes on to talk about how, notwithstanding the foregoing, that Donald Trump's testimony did not match the reality. Donald Trump stated he was not involved in the preparation of the 2021 Statement of Financial Condition, that it would have been prepared by Weisselberg McConney. Trump was aware that receiving loans from the Deutsche Bank Private Wealth Management required him to provide a personal guarantee. When Trump sold the old post office, he paid off the Deutsche Bank loan. When questioned about Weisselberg's guilty plea to tax fraud in connection with his employment at the Trump Organization, Donald Trump challenged that Weisselberg had committed any wrongdoing at all, saying, quote, "I mean, is there something wrong? I mean, IBM executives get apartments that are compensated by IBM, and lots of other companies do, but people that work for me can't be so compensated? I don't know. I don't think that's a big thing, is it?" Overall, Donald Trump rarely responded to the questions asked, and he frequently interjected long, irrelevant speeches on issues far beyond the scope of the trial. His refusal to answer the questions directly, or in some cases at all, severely compromised his credibility. The order goes on to talk about more of the witness testimony. It goes into specifics in the statements of financial condition. It goes through each of the causes of action here that are at play. And then it talks about the appointment of the independent financial monitor, the necessity for continuing oversight, how retired federal judge Barbara Jones identified all of this inconsistent, erroneous, and incomplete financial statements. And then one of the things that are talked about here as well is the lack of any accountability and ongoing nature of the fraud. So that's a short summary of the 92-page order. We'll dig deeper and get you some more portions, but wanted to give you that for now. Obviously, the big headline is this $364 million disgorgement order, the various preclusions on conducting business in the state of New York and with businesses in the state of New York, and the ongoing independent monitorship by retired federal judge Barbara Jones. We'll keep you posted. Obviously, this is a developing story. Wanted to get you the news right away. Hit subscribe. Let's get to 3 million subscribers together, and have a great day.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.